Hello everyone, welcome to our new session. This is Dr.P.Syamala from the Department of MBA, International Business, Acharya Nagarjuna University. Coming to today's topic, our topic is relating to Articles of Association, which is known as AOA. Okay, so what does Articles of Association means? What were the features of Articles of Association, and what are the limitations regarding the Articles of Association can be studied. Okay, so what does Articles of Association means? So as we know, in previous classes we have studied about the formation of the company. Means under formation of company, definitely at the incorporation of a company or else the registration of a company at that time, during that time, company should produce 3 documents, namely Memorandum of Association, Articles of Association, and the prospectus. And in previous classes we have studied regarding the Memorandum of Association, right? Now we are going to study about the Articles of Association. So Articles of Association is next to Memorandum of Association, and we can say this Articles of Association as a subordinate or else the secondary document of Memorandum of Association. Okay, this is also similar to Memorandum of Association, which means that in case of public document, it is a public document. We have studied Memorandum of Association is also a public document. Likewise, Articles of Association is also document, but Memorandum of Association is associated with outsiders, which is known as outdoor management. But coming to this Articles of Association, this is second important document which is to be filed with ROC, okay, which is nothing but Registrar of Companies at the time of incorporation, okay, and it is to be filed with the Registrar of Companies along with Memorandum of Association at the time of incorporation, okay. And this Articles of Association is a public document, and mainly we can say that Articles of Association means which associates within the company, which associates, which maintains a relationship within the internal management. We can say it as indoor management. Memorandum of Association is outdoor management. Its relationship with the persons will be outsiders. But coming to Articles of Association, okay, it is related to the internal management, day-to-day operations, how the day-to-day operations or activities are going on, with whom they have to associate. So all will be related to the internal management or else indoor management. So the rules and regulations or else the powers, the duties, the responsibilities of the people within the organization will be detailed information will be given in this Articles of Association. Means only internal management, okay, the details regarding the internal management, like about the directors, about the shareholders, about the employees of the organization, okay. So within the environment of the organization only Articles of Association will be created, okay. And it defines about the powers, it defines about the rights, it defines about the duties of the board of directors, okay. At the same time, it establishes the relationship between the company and its members, and also between the members in the organization, within the organization. So this is the meaning of the Articles of Association. Now coming to definition. So what does Companies Act, how does Companies Act define the Articles of Association? Means article means according to section 2 subsection 5 of Companies Act, Articles of Association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company's law or of this act, okay. Means according to section 2 subsection 5 of Companies Act, article means the originally framed, it means that whenever it is going for incorporation of a company, okay, the company lay down some rights, powers, duties, okay, of the indoor management, of the internal management. So how should be the relationship between the members of the organization? Okay, so all the details regarding the indoor management will be framed in articles of association depending upon the company's requirement, okay, or else, okay, that is known as company as originally framed, means the meaning is that, or as altered from time to time, means we know that memorandum of association cannot be altered. It is a hectic job to alter memorandum of association. But and also, if at all if we want to change memorandum of association, means there will be a hectic procedure, and we have to take permission from central government, okay, and this ROC, so many aspects will be involved in order to alter memorandum of association. But coming to this, we can alter articles of association from time to time depending upon the or else in accordance with the provisions of company's law or any previous law, okay. So here alteration of articles of association is possible. Why? Because it is related to within the internal management, within the internal environment of the organization. It is in the hands of board of directors, shareholders, okay. So they can change, if at all they want to change any articles, means by the resolution of the directors and shareholders, okay, they can change the internal powers or rights or duties, responsibilities, etc. Everything can be changed, altered, but with a resolution, okay, within the internal management. So it says that, the definition says that articles of association is nothing but whenever the company is going for incorporation, it lays down its duties, its responsibilities, the powers, the rules and regulations regarding the internal management, okay. So all these activities can be laid down at the formation of the company, and which is to be produced to the ROC. So that is the articles of association. And also this section states that articles of association can be altered from time to time according to the provisions of company's law or else the previous act regarding this articles of association, okay. And coming to features of articles of association. So what are the features of articles of association? So it is a part of the constitution of the organization. As I said before, in memorandum of association, it is treated as a charter. Memorandum of association is treated as a charter or else constitution of the organization. As we Indians, we have an Indian constitution. Likewise, organization has constitution, which is nothing but the memorandum of association, articles of association and the prospectus, okay. Three main documents that have to be produced in the ROC, okay. So likewise, memorandum of association, this articles of association is also considered as a part of constitution of the organization. Why? Because this articles of association is a subordinate to the memorandum of association. So this is also treated as part of constitution of organization. And coming to second, it is the contract between the members and among the members themselves, okay. Why? Because this is related to the internal management or else indoor management of an organization. So within the organization, who else will be there? Means the employees will be there, the shareholders will be there, directors will be there, board of directors will be there, okay. So any contracts between them can be seen in these articles of associations. The rules and regulations can be laid down within the articles of associations, how they are related, what are the rules and regulations, what is the procedure to be followed with while going for contract between these members in the organization will be presented in the articles of association. Now coming to third aspect, it lays down the duties of the shareholders, okay. So as I said that within the organization, who will be the persons, who will be the members, means shareholders also will be there. So the duties regarding the shareholders also will be laid down in the articles of association. Now Another one, it is not binding in relation to outsiders. So it is no way related to the outsiders. So memorandum of association is only related to the outsiders. So it is known as outdoor management. But coming to articles of association, it does not deal with the outsiders. So it is not binding in relation to outsiders. Outsiders are nothing but the stakeholders of the company. Outsiders, customers, suppliers, government, bankers, likewise. Okay. And coming to another thing, few statutory clauses should be included in the articles of association. Other clauses can be chosen to make the bylaw of the organization. Sorry, this is not laws, this is bylaw. Okay, LAW, bylaw. So therefore, few statutory clauses should be included in the articles of associations, and also other clauses also can be chosen for. So bylaw of the organization means if at all any laws are needed for the benefit of the company, okay, at that situation they can take other clauses also. Okay, even though we have a statutory clauses regarding articles of associations, we may choose other clauses also which benefit the company. So that is the feature of articles of association. Okay, so through alteration we can include, if at all we want to include anything, means we can through other clauses. We have like certain forms regarding articles of association. So we can take any clause, we can take any tables regarding those articles of associations, models or forms of articles. We can take them and we can include in our articles of associations. Okay, and articles of associations can be inspected by anyone as they are a public document. So as I said before, like memorandum of association and articles of association, prospectus, these three are the important documents, and these three can be inspected by the outsiders. So it is known as a public document. Okay, so this is another feature. AOA can also be inspected by anyone who want to enter into contract with this particular company. They can inspect the public document. Okay, why? Because they can inspect these AOA, MOA, likewise, because they are a public document. Okay, and coming to model form of articles. Okay, so what does model form of articles means? Schedule 1 to the Act gives various model forms of MOA and AOA. For both MOA and AOA, okay, model forms were given. If we studied in this memorandum of association, okay, in that there we have studied about models from A to E, A, B, C, D, E. 5 forms will be there. Depending upon those forms, memorandum of association can be created by the companies. Likewise, models, certain models were given for articles of association also. If a company wants to take follow articles, okay, so it can take from these given forms like F, G, H, I, J. So these are another model forms that were given for these articles of association. Okay, and for memorandum of association we have A, B, C, D, E, those forms. But for articles of association we have F, G, H, I, J in schedule 1. Okay, according to section 5 subsection 6 of Articles of a Companies Act. Okay, so what are those forms means? If we take for example table F, so what does table F? It contains some detailed information regarding the indoor management of an organization, okay, which are treated as articles of association. So this table F will be related to articles of association of a company limited by shares. So this type of company may take this table F form. It means that it can follow the aspects under table F. It can include this table F in their articles of association. Which company means? Company limited by shares. This type of company may directly go for this table F and include this table F in their articles of association. Or else, if at all the company is limited by guarantee, having share capital, okay, then this company may follow table G. Okay, So the framing of articles of association depends upon the forms of articles of association according to the Companies Act, okay, or else the company may own it may own originally frame its own articles of association, okay, depending upon its internal management requirement of internal management, it can frame its own articles of association, or else it may follow these table like F, G, H, I, J, but preferably F is related to limited by shares, G is related to limited by guarantee having share capital, and table H article have the detailed information regarding articles of association, okay, but company limited by guarantee and not having share capital, okay. So this type of company may follow this table, articles of association, okay. Likewise table I, so table I is for unlimited company having share capital, and table J is unlimited company not having share capital, here having share capital, here not having share capital, okay. So for framing articles of association for a company, it may originally form its own articles of association according to the requirement of its indoor management, or else it may follow this table depending upon the type of the company, okay. So this is about the model form of articles of association. So in this we can study, we have different types of company like public limited company, private limited company, and one person company, OPC, okay. So if we see public company and private limited company, so how these articles of association applicable? So if we see according to section 5 subsection 7, a company can adopt all or any of the regulations contained in the model articles table F, okay, table F. So a company can adopt, okay, the regulations or else adopt all which are contained in the table F form. If we see here table F, so table F is basically related to the limited by shares, okay. So it can follow this table F, okay. So and it can formulate and register its own articles of association, okay, or else it may partially adopt table F and also have its own article. It may adopt table F if it wants, or else it may have its own articles of association. So if we can say that section 5 subsection 7 provides that a company may adopt all or any of regulations contained in the model articles applicable to that particular company. So therefore a company may either formulate and register article of its own within the provisions of the Act and the memorandum of association, okay, or it may adopt all regulations contained in the model articles according to table F, or else partially it may adopt table F and also have its own articles. It means that half table F, okay, and half its own article. So partially it may adopt table F, partially it may adopt its own articles of association. So all these can be considered under public limited company. If at all, if we go for private limited company, means it must have article of its own, okay, and it must contain the restrictions as provided in section 2 subsection 68. So if we go for private company, it must have an articles of association of its own only, and also it should follow the restrictions according to the Companies Law Act, okay, which is categorized under section 2 subsection 68. There are some restrictions while forming the company, okay. So it has to follow all these regulations and restrictions while framing the articles of its own. According to these restrictions, company's restrictions only, it should frame its articles, its own articles of associations regarding this private limited company. And coming to this, without following these restrictions, if at all the private limited company have not followed this section 2 subsection 68 restrictions, means it cannot have the status, it cannot have the status of private limited company. Okay, so this is about the model forms of articles of association according to the Companies Law Act. Now coming to contents of articles of association. So what does articles of association consist of? Okay, so while before framing the articles of association, okay, so we should take care regarding the preparation of the articles of association. Okay, here utmost care must be taken to prepare the article. Okay, utmost care while preparing the articles of association, we should take care. Why? Because if at all it is a public limited company, it should follow the forms, model forms from F to J. Okay, or else if it is a private limited company, according to section 2 subsection 68 of Companies Law Act, okay, restrictions were there, and it has to beyond the not beyond, within the restrictions, within the provisions of the Company Law Act, it should prepare the articles of association. So they should take care. Okay, utmost care must be taken to prepare the articles of association. So there are certain matters in respect of which powers can be exercised by the company only if it is article, so and so provide and in the manner provided therein. Okay, so there are certain matters for each company. In internal management, there will be many matters, many issues. Okay, so regarding powers, okay, so for example, we have shareholders, we have the employees, we have the directors, board of directors, managing director. So many people will be there in an organization in order to manage. Okay, so each members will have their different powers, okay, rights, duties to perform. So we have to lay down properly regarding these powers, okay, which have to be exercised within the company only if its articles so provide. So if at all these powers should be exercised in the company, means all those list of detailed information should be in these articles. Okay, articles should provide, and in the manner provided there will be execution in the organization. Okay, now articles usually contain rules regarding following matters. Okay, what are those rules? Means basically these are the primary rules for articles of associations, because all these aspects will be there, all these are the elements or contents that are involved in the articles of association. Okay, if we see first thing, adoption of preliminary contracts. Okay, so whenever a company is entering into a preliminary contracts, definitely there will be certain procedure will be there, the persons involved will be there, so all should be considered. Okay, then only they have to lay down the articles of associations regarding these contracts. So therefore, while laying down the articles of association, okay, so they have to give a proper procedure, the persons to be involved regarding these preliminary contracts. Okay, likewise this articles of association involves the number and also the value of share. So they will give in articles of association only how many number of shares are there and what is the share of each value, or else what are the equity shares, what are the preferential shares. Okay, so the detailed information will be there in the articles of association. And coming to allotment of shares also, so how many equity shares, how many preferential shares, likewise. And coming to calls on shares, okay, here there will be like first call, second call on shares, like for example, for 50 rupees share, shareholder pays 25 rupees and 25 rupees is in balance. So here the person, the company will give first call and second call. Okay, so for first call he paid 25 rupees, and the remaining 25 rupees will be paid in second call. So that is known as calls on shares. And here lien on shares, this is nothing but lien on shares is the transferability of shares, means the shareholder cannot transfer his share to others without paying the amount. For example, if a shareholder has to pay a 5,000 amount to the company, okay, regarding these shares, without completely paying that 5,000 amount, he could not transfer his shares to others. Okay, so that is known as lien on shares. Coming to transfer and transmission of shares, this is also likewise. So there will be certain rules and regulations regarding the transfer and transmission of shares. Coming to forfeiture of shares. So forfeiture of shares means nothing but cancellation. Okay, cancellation of shares. So forfeiture of shares means cancellation of shares. So this cancellation of shares will be done in which case? Okay, so whenever a shareholder owes some money to the company, okay, he is not paying that money, means in that case the company will cancel the shares of that shareholder. So that is known as the forfeiture of shares. And coming to alteration of capital, if at all the company want to change the capital, means alteration of capital. So we all know authorized capital, paid up capital. Okay, so authorized capital is the total capital of the company. So it will give that detailed information to ROC while incorporation of the company. But if at all it want to alter the capital, means, so what is the procedure, who are the persons involved in it, who should be sign on those documents. So all this detailed information will be given, laid down in the articles of association. Okay, and now coming to conversion of shares into stock. So how shares are converted into stock, what is the process and persons involved. Okay, likewise voting rights and proxies. Meetings, whenever meetings means that any company will conduct general meetings, special meetings. Okay, so whenever they have to conduct annual meetings, whenever they want to conduct general meetings, whenever special meetings are going to be conducted, so detailed information will be laid down in the articles of associations. Likewise directors, their appointments, their powers, their duties, their remuneration. Okay, all these aspects also will be laid down in the articles of associations. Now coming to borrowing powers. So borrowing powers, to what extent a company can borrow, or else to what extent that directors can borrow. So what are the powers regarding the borrowing aspects. Okay, likewise dividends and reserves also. So these dividends are nothing but whenever the shareholder invests some amount in our organization on behalf of the shares. Okay, so some dividend is paid to those shareholders. So that is the dividend. So how much percent of dividend should be given. Okay, so those aspects will be laid down in articles of association. Coming to reserves also, how much reserve should be maintained in the company. Reserves are nothing but some amount will be kept aside. Okay, so how much reserve amount should be kept in the balance sheet. Likewise, and how accounts should be audited. Okay, what is the time period whenever auditing should be done. Likewise winding up of company. So at the time of winding up of company, okay, so what is the procedure. Okay, and how much amount should be paid, equity shareholders, preferential shareholders. Okay, so secured creditors will be there, unsecured creditors will be there. So the whole aspects, detailed information while going for winding up. So the whole information will be laid down in the articles of association. Okay, now coming to alteration of articles. Okay, so alteration of articles of association. So if we see in memorandum of association, okay, alteration is difficult. Okay, we cannot easily change or else alter the memorandum of association. But articles of association can be altered. So that is why we can say that it is a statutory right of a company. Okay, so depending upon the internal management of a company, okay, depending upon the requirement, if at all it benefits the company, means definitely it has a statutory right to change the articles of association of a company. So company can alter its articles of association. Okay, so if at all it alters, means what is the procedure? Okay, so procedure for alteration of articles of association under section 14. Okay, under articles of section 14, this is the procedure for alteration of articles of association. Okay, so what is the procedure? Means first one is approval by the board of directors. So if at all we want to change the articles of association, means first of all the proposal has to be approved by the board of directors. Okay, so first of all board of directors, and if at all they approve, means they will fix the date and time for the general meeting. Okay, so the secretary, he shall convene the meeting on the appointed day. Okay, in the meeting the necessary special resolution amending the articles of association shall be passed there. Okay, so that is the special resolution. So special resolution means secretary shall convene the meeting. A special resolution will be passed in the company. Okay, now so there will be shareholders, there will be directors of the company. Okay, depending upon the requirement, they will pass a special resolution which is conducted by the meeting by the secretary. Okay, and AOA shall be passed. And coming to third aspect, okay, intimation to ROC. Okay, so how much time? Within 30 days of passing of resolution, a certified copy shall be filed with the ROC, Registrar of Companies. Okay, of section 117 of the Companies Act. Definitely company should intimate to the ROC. They should file a copy, a certified copy regarding the passing of resolution within 30 days. Okay, they have to file that copy with Registrar of Companies. Now coming to another aspect, where the alteration articles includes conversion of a public company into a private company, the company shall seek the approval of the tribunal, which shall make such order as it may deem fit. Okay, here fourth aspect, where the alteration articles include conversion. Here we are going for conversion of a public company into a private company, if at all. Okay, then we have to get approval from the tribunal. Okay, or else the court. So where the court make or else give order as it may deem fit or not. An order will be given by the court or else the tribunal. Okay, so if we see this one, so this is not there. First one, second one, third one, intimation to ROC. After intimation to ROC, this is seek approval if conversion of, this is first one, this is second one, this is third one, this is fourth one. Okay, fourth one is seeking approval, okay, from tribunal. For what purpose? Means for conversion of public company into a private limited company. So, and the other one, fifth aspect is, fifth procedure for articles of association is intimate ROC of approval of tribunal. Okay, so after getting the approval from the tribunal, okay, so as we went for the approval of a tribunal, okay, for converting our public company into a private company, okay, so immediately we have to intimate that thing. Okay, that approval of the tribunal, the printed copy of the articles okay, as altered should be filed by the company with ROC, Registrar of Companies, within 15 days of the date of receipt of order of approval. Okay, so within 15 days we have to intimate with ROC. Okay, we have to the altered copy should be filed with the ROC, Registrar of Companies, within 15 days of date of receipt, okay, of order of approval from the tribunal. Okay, now coming to sixth aspect. So it is intimate sector exchange. Okay, so intimate sector exchanges means 6 copies of the amendments should be sent to the stock exchanges on which the shares of the company are listed. Okay, so totally after getting order or else approval order from the tribunal, okay, 6 copies of amendments should be sent to the stock exchange. Okay, why? Because there our company shares will be listed, so therefore we have to send 6 copies to the stock exchanges. Then the last thing is alteration should be noted in every copy of the Articles of Association. Alterations should be noted in every copy of alteration of Articles of Association, and the articles issued after the date of alteration should be in accordance with the altered articles according to section 15. Okay, so here alterations should be noted in every copy of Articles of Association. We have Articles of Association with a detailed information. So the changes made should be we have to include them in the Articles of Associations. Okay, so a default in this regard shall invite penalty. Okay, so the process we have till now we have seen, if at all if at all company if follows any default in this regard means a penalty against the company will be there, as well as with the company, as well as the officer in default also has to pay the penalty. So the penalty provided under the section is rupees 1000 for each copy. Okay, so issued for rupees 1000 rupees fine will be meant for the officer and also the company. Okay, penalty against company and also the every officer who is involved in it will be considered as a defaultee. Okay, and penalty should be paid by them. So this is about the procedure of alteration of Articles of Association.